I do have one other question for you. Um, in terms of, there's so much information out there. There used to be a couple of large eDiscovery cases per year that everyone knew about. But now, there's so much information out there that it's kind of hard to know what do you need to keep track of in terms of, eDiscovery technology, case law. Do you have some suggestions of ways that people, especially when they're working from home remotely and they're not around their colleagues physically speaking with them and hearing what they have to say, to kind of stay on top of those types of subjects?
Yeah, sure, David. Thanks for asking that question. So what I've noticed in the last couple of years is, and as you just pointed out in the question, we're not seeing those big precedent setting cases anymore. There's not the big headlines on law.com about the particular, precedent setting e-discovery cases. People aren't making, at least not newsworthy, gargantuan e-discovery mistakes anymore. Judges' tolerance level has decreased for those mistakes. And so lawyers have generally stepped up to the plate on that. Most people have pretty much figured it out. One of the trivia questions I often start my introductory classes on eDiscovery is about what year did the Federal Rules of Civil Procedure originally get updated to consider electronic discovery? So I'll ask you that question, David, just for kicks. What year do you think the Federal Rules of Civil Procedure were originally updated to address e-discovery?
If I had to guess, I'd say 2008.
Close. Close in the common sense. I'll say that. 2006, 2005 was the 2006 rules is when they were updated and everybody really took notice. But the actual answer, and why it's a trivial pursuit type of thing, 1970. The
Oh, wow.
1970 federal rules said digital data. They used the word digital data, and in the comments, they were really around that time. What was going on in the late 60s is you had Star Trek on TV, you had NASA putting a man on the moon type stuff going on. And what I always tell my students is in Star Trek, the automatic doors on the bridge when Captain Kirk and Spock come in and the doors go swoosh and they open.
Right.
And so that actually hadn't been invented yet when Star Trek was on TV. That there were stagehands on either side timing opening and closing the doors.
Right.
It wasn't until a few years later that shopping malls, and actually the first one that had the sliding doors was Dadeland in Miami. Because I lived in Miami, when I learned all this stuff, I learned all that. But it was Dadeland in Miami was one of the first indoor shopping malls that had the automatic doors that, were motion censored. Anyway, the reason the rules were updated is because you had all of that new technology going on, and mainframe data was starting to eke its way into litigation matters. But because everybody could just print a report and lawyers were happy with the paper report, no one really questioned it. But I've worked with attorneys who actually have had data reports from as early as the 70s and 80s that came out of mainframes, that it was a big deal. And some of the larger technology companies, manufacturing companies, had data issues that came up in the 80s and early 90s. And so by the time we get to 2006, the courts were like, okay, this is really a problem, because in the 90s, you had the internet. You had the World Wide Web, you had Netscape, you had Windows 3.1. So you had the GUI interface. Everybody was using computers, which meant it's all showing up in litigation. But so we had all those precedent setting cases in 2003 and 4 and 5. The federal rules were updated in 2006. And now, from a career planning standpoint, from a work-life balance standpoint, how do I stay up to date on all that when I look on law.com or I Google eDiscovery News and there aren't any big cases coming up? How do I know what's happening in the trenches? Something really simple, really easy. You're probably going to go, oh man, I should have thought of that. A Google alert, and specifically a Google Scholar alert. So I'll send you the link, David, so that you can put it in the comments.
I've
for
never,
the,
I've heard, of course I know about Google Alerts, but I'm not familiar with
Mhm.
the Google Scholar Alert.
So Google Scholar lets you look up journals like the Journal of American Medicine, the journal articles, but it also lets you look up case law. So if you select case law, type in eDiscovery, then what you get back, and you can set, the frequency that you get the alerts. It could be every other day, every day, once a week, whatever's convenient for you. But when you get the alerts, what you get are any of the cases that show up with the word eDiscovery in it, which is a lot of cases these days in litigation. But what's valuable about that from a time management standpoint, especially if I'm an eDiscovery project manager or litigation paralegal trying to stay on top of things, is the wording of orders, eDiscovery orders. What kinds of things are showing up? I saw a case the other day where the one party was responsible for providing a laptop for the other party to review data on. I saw another case the other day that had information specifically about the scope of the Rule 26F conference for the meet and confer rule. Very specific information that I always cover in my classes about what you want to look for or make sure is included. Another one had defined terms. Here's what we mean when we say this. Another one that I looked at this morning covered what to do with the data when the case is over, when the project is over. So the obligations on conclusion of litigation, the parties agree to destroy the documents to the extent possible, or their copy of the documents, or the retention of attorney work product, any notes that we made about the documents. What do we do with all of that? From a project management standpoint, those are all things that we talk about all the time in class. Another agreement, another
And
case. Oh,
sorry
go
to
ahead.
interrupt, but you definitely need to stay up on those, because if a policy changes and say, you're required to retain data for, uh, or not retain data,
Mm-hmm.
and then, you finish up a case and you do what was right a few months ago and you're not up to date on the updates, you may have just made a costly mistake.
Well, yeah, I was teaching a class probably over a decade ago in around the time, around 2005-ish, before the federal rules were formally updated, when everybody was just talking about it, and we were talking about the Zubilate cases. The One of my students, when this question came up in class, what do you do with old data? And she was like, oh, I have a box under my desk. I just toss stuff into it. And I was like, yeah, no, um, we can't do that. You need to go back to those clients and find out what's going on. And the reason is because there have been cases where, the lawyers change for a party. And so the new lawyers or in the new case don't realize there's old data sitting around that was supposed to get destroyed by the last firm, and it could become discoverable in the new case. And you want to be very careful about what you do with the data. Being able to be aware of current case law gives a project manager uh, something to stand on, a foundation and authority to say to the attorneys and the paralegals, hey, no, this is from last week. We need to make sure we have this done.
Right.
This is what happened with this other case. It may not have made the news, it wasn't flashy, but here's what other people are doing. Another example that I saw recently had to do with parties just simply, which happens a lot, not being in agreement about the compelled to discovery. So the judge is issuing an order. And what was interesting in this order is the judge references a bunch of older cases. So you've got like the who's who of cases that this particular judge in April of 2021 was referencing in their decision,
Right.
that were hyperlinked in the Google alert, that I can now go back and look at and go, oh, this is what they did. This is why this is relevant. This is similar to another case that I may have worked on, or it will trigger a conversation if I bring it up to my attorneys that I'm working with. And so while there may not be any big hoopla precedent setting cases right now that are newsworthy, having that Google Scholar alert gives me something that I can just quickly search my inbox for Google and Google and eDiscovery and pull up those emails and for the last couple of weeks and go, oh, this is what's going on. These are the kinds of things, or find an example of an order, of a decision, of a scheduling order. What kind of timing did somebody else use? So it's a way to manage my time, make the most of my time, maybe before work on a work day if I'm working from home.
Right.
And it's something easy that I don't have to go and search or pay for a service, for a new service to get to.
That's a great idea. Thank you for sharing that. I think a lot of people will find that useful. And you're right, there is a lot of information out there. So finding a way to consolidate it and have it sent directly to your inbox and then have it easily accessible when you do need it, saves a lot of time and make your life a lot easier.
Oh, definitely, definitely. And it's great, especially for me as a trainer. I don't train every week. And that's a lifestyle choice that I've chosen. So I'm particular about when I schedule training, and I know that I can always go to my Google Scholar Alert to find out what's current.
Right. Absolutely. It's always a good idea to have alerts about other things too, if you're dealing with data, maybe in different locations, certain keywords.
Yeah, mine's generic to eDiscovery, but I mean, you could put in intellectual property terms, construction litigation, whatever it is, that practice area that you're working in, certainly.
Exactly. Or, the GDPR, the changes to the California privacy, and then all these other states and countries, and everyone's kind of coming up with their own policies. So if you got to watch out for that stuff, keep the information coming.
Oh, definitely. Definitely.
All right. Well, thank you for that. And
Thank you.
yeah, I think we went over some great information today. And I'm looking forward to our next installment, which we'll be announcing over the next several weeks. And as always, it's been wonderful chatting with you today, and I appreciate your time.
Likewise, David. Thanks so much. And thank you to our listeners too, who are hanging with us on these short videos. I hope they're helpful.
Yeah, absolutely. And don't forget to go back and check out some of the videos we put on in the past. There's some great topics on there, and they'll be available on the YouTube channel for whenever you'd like to check them out.
Definitely. Take care, David.
Thanks, you as well.